Assalamualaikum warahmatullahi wabarakatuh. This is Zoom recorded lecture for Law of Contract 2 for the topic misrepresentation. This is the topic for our syllabus of Contract 2. Okay, let's have a look at what I have here. And this is the outline of the lecture, basically. So we are going to discuss the definition briefly. And then this part will cover conditions to be fulfilled before misrepresentation can be actionable. So that basically there are two conditions. So this part of the lecture, of the recorded lecture, will cover the first condition, which is false statement of facts. And then I'll continue with inducement, as well as position of silence under English law, which comes with exceptions, and as well as position under Contracts Act 1950. So we'll go straight to the definition. So basically, misrepresentation is another vitiating factor other than the one that we have discussed so far, which were coercion and then undue influence. So coercion under section 15, undue influence under section 16. Okay, and section 17 covers fraud, which is our next topic, and section 18 it spells out misrepresentation. So this is the reproduction of the provision in Contracts Act 1950. So there are three clauses here. Okay, we have A, B, C. And this is some of the circumstances in which misrepresentation might happen or might occur. So the first one, misrepresentation includes the positive assertion in a manner not warranted by the information of the person making it, by the maker of the statement, of that which is not true. Meaning that here information is not true, though he believed it to be true. So the maker of the statement believed the information that he said, is true. Okay, that's the first one. This is the most common example, of misrepresentation. Okay, B, clause B, or the second circumstance, any breach of duty which, without an intent to deceive, he give an advantage to the person committing it or anyone claiming under him by misleading. So that's the keyword, misleading another to his prejudice or to the prejudice of anyone claiming under him. So that's the second situation. The third one, causing, however, innocently. So that's the keyword. Okay, the emphasis is on the part innocent. Innocently, a party to an agreement to make a mistake as to the substance of the thing, which is the subject of the agreement. So this is the three situations in which misrepresentation might occur, and this is provided under Section 18 Contracts Act 1950. But if we look closer, can we see the conditions from this situation here? There are, we cannot see clearly, expressly conditions for misrepresentation. Okay, but if we refer to common law, common law has laid down two important conditions or requirements for a misrepresentation. Okay, so now we are looking at common law. Okay, but whether we follow or not, so basically we follow the similar approach as what is practiced or implemented under common law. So there are two important conditions to be fulfilled before misrepresentation can be actionable, before the party can claim or can bring an action based on misrepresentation. The first condition, the first element, there must be false statement of facts. The statement must be false and it relates to facts. So, and having said so, facts here, it doesn't include opinion. Meaning here, facts and opinion, they are two different things altogether. Or it won't include future intention, or it won't include law as well. So fact is fact. It's very specific here. It has to be statement of fact. It cannot be statement of opinion. It cannot be statement of future intention, or it cannot be statement with regards to law. So what if the statement is about opinion? Then it is not a misrepresentation. So it doesn't fulfill the first element. So we have the case, this is the landmark case for which discuss about statement of opinion here. The case of Bissett and Wilkinson, common law case reported in the year 1927, so classic case here. So plaintiff was the purchaser of a piece of land, and defendant was the landowner. So what happened was that plaintiff actually, he purchased from the defendant 2 blocks of land. And what's the purpose of purchasing such land? He wanted to do some sheep farming. And during negotiations, defendant said that if the place was worked properly, it will carry 2,000 sheep. So relying on this particular statement, but then this particular statement is not included in the terms and conditions of the contract. So, but it was said by the defendant during negotiations before they signed a written contract. So now the plaintiff, the purchaser, bought the place, bought the land, and he believed that it will carry 2,000 sheep, as stated by defendant, the owner, the landowner, the vendor. And then actually, as far as the parties are concerned, both of them, they were aware that defendant here had not carried on sheep farming on the land. So nobody can tell for sure how much, how many sheep can be, can accommodate on that particular land. But later, later the plaintiff, after he bought the land, then he discovered that, oh, actually the land could not accommodate 2,000 sheep as stated by the defendant. So this is the statement, the observation by the trial judge. He said that in an action for misrepresentation, you can read on your own here. All right, the last part here, defendants were not justified in regarding anything said by the plaintiff as to the carrying capacity as being anything. Because why? This is just a mere expression of his opinion on the subject. It's not really a fact because he doesn't know. He never had any sheep farming on his land before. So whatever he said during negotiation is just a matter of opinion. And then the case went up to Privy Council. That's why it's a landmark case here. And Privy Council concurred, agreed with the view of trial judge. And then Privy Council affirmed that in the absence of fraud, in this case, there's no fraud whatsoever, no element of cheating whatsoever. So now the purchaser had no right to rescind, cannot set aside the contract based on misrepresentation. Why? Because it's not statement of fact. So the first condition is not fulfilled. But then take note, we must be able to differentiate from another situation here where the person giving the statement, the maker of the statement, was in a position to know the true facts, and then it can be proved that he could not reasonably have held such view. As a result, then in that situation, even though he said, oh, this is my opinion, but he knows about it, he knows the truth. So in that particular situation, his opinion will be treated as statement of fact. It's no longer statement of opinion. So the first element is considered fulfilled. So this is what happened in the case of Smith and Land and House Property Corporation. So plaintiff in this case was the hotel owner, and defendant was the purchaser of the hotel. And plaintiff put up his hotel for sale, stating that it was let to a most desirable tenant. Meaning that here this is to attract all the potential buyer. Say that, okay, my hotel is good, and then we have desirable tenant in our hotel. And because of that, because of this particular statement here, defendants agreed to buy the hotel. But actually later, he discovered that the tenant was bankrupt. So it's not really most desirable tenant here. So now defendants, after discovering this fact here, defendants refused to complete the contract. And because of that, now plaintiff sued the defendant for specific performance. To compel the defendant to complete the contract, to proceed with the contract. But Court of Appeal held that plaintiff's statement, the most desirable tenant here, was not a mere opinion because he knows the actual position of the tenant, whether he's a bankrupt or not, financial position of the tenant. So here is not a mere opinion. The statement is actually of facts, one of facts. So this is false statement of facts, misleading. Okay, what if the statement, with regards to the future, can we hold that the statement is statement of facts here? So the law says that, the rule is that a false statement by a person as to what he will do in the future, generally is not a misrepresentation. That's general rule. And obviously, legally speaking, it will not be binding on a person. unless the statement is incorporated into a contract. Then that's a different scenario altogether, because later, if there is anything not true later, then the party can sue for breach of contract. Okay. However, I mean, this is a very balanced rule. Generally, it's not. But however, if a person knows that his promise, I mean, promise is something in the future, which has induced another to enter into the contract, will not in fact be carried out, then he will be liable. When he makes it, it is yet to happen. And it's just a matter of promise. But he knows, he knows for sure, it won't be carried out. I mean, it won't take place whatsoever about the promise here. So in that particular situation, statement to the future here is equivalent to statement of facts. It's considered as statement of facts. This is the case of, I mean, this is what happened in the case of Edgington and Fitzmaurice. What happened in this case, very old case, 1885, plaintiff, the shareholder, they received circular, issued by the directors, and the directors were requesting loans, to the amount of 25,000 pounds sterling with interest. And then in this circular, the circular is not part of the terms of the contract. Now the circular stated that the company had bought a list of a valuable property. And why they're asking for a loan now, so money was needed for alterations of and additions to the property and to transport fish from the coast for sale in London. But later, actually, it was discovered that the circular was misleading. So that's why they brought the case to the court. So the circular was challenged as being misleading in certain aspects. And then this is the allegation. It was alleged that it was framed, it was written in such a way so as to lead the belief that the debentures, the loan, would be a charge on the property of the company. And that the whole object of the issues was to pay off pressing liabilities of company, not to complete the alterations, etc. So meaning here, whatever that whatever stated, written in the prospectus, I mean, it turns out to be something else. I mean, it wasn't really carried out, whatever in the prospectus here. So now, actually, the plaintiff had taken debentures. Debentures is like a loan. You are giving loan to the company, but you are the shareholder. So they claim repayment of his money on the ground that it had been obtained. The debentures had been obtained by him by fraudulent misstatement. I mean, the statement was not true when it was stated, the circular. So the Court of Appeal held that yes, the statement of intention, whatever they're asking for, I mean, they asked the shareholder to buy debentures, and then they said, oh, this is the purpose of having the debentures, but actually the money was used for something else. So the court held that statement of intention was a statement of facts, and yes, it amounted to a misrepresentation. And for that purpose, plaintiff was entitled to rescind the contract. And even though the statement was a promise of intent, I mean something to be done in the future, but the court held that defendants had no intention of keeping to such intent at the time they made the statement. I mean that they know from the very beginning they are not going to use the money for whatever that, which is written in the prospectus, but they use the debentures for something else. And this is what the plaintiff was not happy with the with the one, I mean, with the act of the defendant. Okay, what if the statement is statement of facts here with regards to the law? So basically the rule is straightforward. So a false statement as to the law is not actionable misrepresentation, because what's the reason? Everyone is presumed to know the law. Ignorance of law is not excuse. But then again, how do you tell this is statement of facts, this is statement of law? So distinction is not really simple. Sometimes it's a mixture. So how do we draw the line between these two? Is it facts or is it law, or is it a mixture of both here? Okay, we are done with the first condition, but then this is further explanation. Just now, if the statement mean that here this is something positive, the one who uttered it, who said, then he said, I mean, it is something which is in positively said, or it is made, a statement is made. What if no statement is made? I mean the maker of the statement, I mean the representative, we have the word representative just keep silent. So can we say silent is actually a misrepresentation? What's the rule here? So the general rule is that silence is not a misrepresentation. So generally you cannot, I mean plaintiff cannot sue defendant for keeping silent. And then because of him keeping silent, then it amounts to misleading of certain statement, for example. Cannot. Okay, generally, no. And then this is actually parallel to a maxim, legal maxim, caveat emptor. What is caveat emptor? Caveat emptor is very specific maxim here. It's between buyer and seller. Okay, so literally it means let the buyer beware. Okay, meaning that here in general, the buyer has the higher duty. Okay, the buyer is expected to look to his own interest to check before he proceed to buy. Okay, and then on the part of the seller, okay, the other party has no duty to disclose problems voluntarily. I mean, the seller has the right to just keep silent, okay, provided the buyer doesn't ask anything. Okay, I mean, the buyer just go and check and then he's happy with it. And the seller doesn't have to tell, oh, this thing is not good or this thing has certain weakness, for example. No need to tell. So seller has the right, no legal duty to disclose problems voluntarily. That will be different if the other party makes certain inquiries. Okay, but if nothing is said and buyer just proceed to buy and later he regret of buying why he didn't ask, for example, then that one is too bad. I mean, we can apply this maxim caveat emptor to protect the seller. Okay, because why? A law imposes the duty on the buyer to check. Okay, let the buyer beware. But this is the general rule. Okay, that's why. Okay, what's the effect of caveat emptor here? Okay, if one party, usually the buyer or even the tenant, okay, if one party is laboring under a misapprehension, okay, there is no duty on the other party to correct it. All right. Example of the case here: kids and lot car organ. In this case, defendant let the plaintiff a house that the defendant knew was in a ruinous condition, not in a good condition. Okay, very very bad condition. And defendant, he knew about it, but he just kept silent, and plaintiff didn't ask about it. Okay, the defendant kept silent without disclosing the facts to the plaintiff. After all, plaintiff is supposed to check, okay, do the checking before he agreed to be in the house, okay, to be the tenant. So the court held that yes, in this particular case, okay, the principle of caveat emptor applies. And plaintiff should have inspected the premises before renting it, and he didn't do so. So later, when he discovered, it was too late already. I mean, the maxim actually applies against him. Basically, it will be different if he asked about it. Here, he didn't ask. Okay, he just proceed, he just signed, and later he discovered it later. So it's too late actually to withdraw from the tenancy agreement here. And this is the rule, okay, affirmation of the rule here. Okay, in Smith and Hughes, it is stated that this is part of the judgment. There is no legal obligation. Okay, there could be moral obligation, but there's no legal obligation, okay, on the vendor to inform the purchaser that he is under a mistake which has not been induced by the act of the vendor. So it's not the vendor is not the one who caused the purchaser to buy. I mean, it's the choice of the purchaser to buy, right? But so there's no legal duty on the part of the vendor. But then the rule is very balanced because why? We have exception as well. Okay, the rule seems unfair in some situation. That's why we have exceptions which are applicable to some situation here. So there are at least 4 exceptions. This is all under common law, English law. Okay. The first one, half truth. Second one, statement which become false. Okay, and then the third one, contracts of iuberem fide, and the fourth one, fiduciary relationship. Okay, what if half truth here? Okay, remember we're discussing exception to the position of silence, so exception to the rule of silence here. Okay, for half truth, okay, representative, for example, the vendor, okay, must not misleadingly tell only part of the truth. Meaning, if you are telling him, if you are telling the other party, then tell everything. Cannot conceal half and then disclose half. So a statement does not that does not present the whole truth may be regarded as misrepresentation. Example between A and B here. If A is the finance company, for example, while giving credit reference concerning B, and A states that okay, B is honest. I mean, B is trustworthy, but he does not disclose that B has been bankrupt. So he just disclosed half, okay, of the facts about B here, but he doesn't tell B has been bankrupt. So in that particular situation, okay, A may be regarded as making a misrepresentation. It will be different if A doesn't give any statement at all. Okay, that one we apply general rule. Here, the moment A is saying something about B, then A must disclose everything. He cannot conceal half and then disclose half. What more, the statement is very, very important, okay, material to that purpose. The statement was made. The statements which become false here. So where a statement was true when made out, but due to a change of circumstances has become false, okay, by the time it is acted upon, then in this particular situation, there is duty to disclose the truth. For example, when they negotiate, okay, the contract, situation is like that. Okay, but later when they sign the contract, situation has changed, and actually if the matter is disclosed to the other party, it will affect the decision to sign the contract, for example. So in that particular situation, statement which the circumstances, okay, which has changed here, all right, statement has become false, okay, by the time it was acted upon, then there is a duty, legal duty on the part of the party who knows about it to disclose the truth. Okay, so in the case of With and O Flanagan here, the court said that if a statement has been made which is true, okay, at the time, but during the course of negotiation, it becomes untrue later. There's a change in the statement. Then the person who knows about it, okay, who knows that it has become untrue, so he is under an obligation to disclose, okay, to the other party, okay, the change of circumstances. But if there is no change of circumstances, then the exception won't be applicable. The third one, okay, specific contract. Contracts Uberme Fide. Okay, it means contract of the utmost good faith. And this kind of contract, it imposes a duty of disclosure of all material facts. Okay, because why? One party is in a strong position to know the truth. That's why he has the duty to disclose all important facts here. So the very, very common example, typical example of contracts of Uberme Fide here is contracts of insurance, okay, between insurer company and also the assured one, okay, the client here. Meaning that here in that particular position, okay, there is a duty on the insured, the client, to disclose every circumstance, okay, which will influence the judgment of the prudent insurer. For example, if with regards to medical insurance, okay, so the insured, okay, the client must disclose whether he has any illness or not. Okay, cannot really keep it secret. Okay, must disclose everything. Cannot withhold, okay, the facts here. In fixing the premium, because it will affect the premium. The higher is the risk, then the more expensive is the premium. And sometimes the insurance company will say, oh, we are not going to cover you. We are not going to give protection to you because of your current medical health, for example. Okay, in deciding whether he or she will take the risk. The fourth one, fiduciary relationship. Okay, the phrase is quite common because we discussed this one when we come across this particular word fiduciary when we discuss undue influence. So what is fiduciary relationship? Okay, relationship of trust and confidence. So where there is a fiduciary relationship between the parties to a contract, so in that particular situation, okay, a duty of disclosure will arise. They are not stranger. Okay, they have relationship of trust and confidence. So in that situation, they cannot keep silent. Okay, the party who knows about it must tell the truth. Okay, for example, solicitor and client, bank manager and client, trustee and beneficiary, interfamily agreements. Okay? So they have all what we call as a relationship of trust and confidence. So we cannot apply that silence won't amount to misrepresentation. Here, okay, if there is fiduciary, then silence might mean misrepresentation. Okay, might give rise to misrepresentation. Okay, do we follow all the rules that we have been discussing here? Okay, the conditions, position of silence. Basically, the answer is yes. Okay, especially if we refer to section 18B just now, okay, it talk about the duty to speak, okay, legal duty. So basically, it relates, okay, to the fiduciary relationship just now. Okay, so that's why silence in certain situation may amount to misrepresentation because whenever there is a duty to disclose as imposed by law. And then we have explanation to section 17 to be read together with section 18B. Okay, let's have a look at the Contracts Act. Okay, here. 18B here, all right, it talk about breach of duty. So duty here, actually, we cross-refer to fiduciary relationship. Explanation to section 17. Okay, section 17 is unique because it has explanation, okay, and section 18, it has, okay, section 19, it has exception and explanation. Okay, section 17, explanation, what does it here? Okay, mere silence, you talk about silence here. Actually, explanation here, it is applicable to both 17 and 18, both cases involving fraud as well as misrepresentation. So it says here, mere silence, okay, as to facts likely to affect the willingness of a person to enter into a contract is not fraud. I mean, if the person keeps silent, then it is not fraud. It is not misrepresentation unless, so unless here it means exception. Unless the circumstances of the case are such that regard being had to them, okay, it is the duty of the person keeping silence to speak, okay, or unless his silence is in itself equivalent to speech. So meaning that here in that particular situation, we cannot apply the rule silence doesn't mean misrepresentation. Okay, in this situation, silence might amount to misrepresentation. I mean, here there's a duty for the person to speak, or maybe silence means, is equivalent to speech. This is all example here. For example, illustration B, okay? Here is between father and daughter, okay? So this is fiduciary in nature. B is A's daughter and has just come of age, okay? Become, 18 years old. So here the relationship between the parties will make it A's duty to tell B if the horse is unsound. I mean, they are selling, sale and purchase of horse, and there is fiduciary relationship between them, okay? So the other, the one who knows about it cannot simply keep silent. That's a legal duty. So this is about, it is the duty, okay, of the person keeping silence to speak, okay, because there is relationship between them, relations here, okay? Okay, we go back to the slide. Okay, we were here. Okay, position of silence under contract. So, but generally, okay, in short, we follow, okay, our law is parallel, okay, or we follow the same approach, like what is what is practiced, okay, or what is applied under common law. Okay, let's have a look at the case here. This is common, this is local case. Lau Hitia and Hargil Engineering, Senambahat. This is, it involved hire purchase of loader, like in the picture, loader. And then in making the observation, okay, in giving the judgment, the court referred to explanation to section 17. Okay, the court want to see what's the connection between the parties here. And the court concluded that there was no duty on the part of the respondent to inform the appellant, okay, the year of manufacture of the machine. And also there's no duty, okay, for the respondent to inform the appellant that the loader had been involved in a minor accident earlier, okay, before the transaction took place. And then actually, okay, the case was decided based on section 17. But section 17 is closely connected to section 18, especially the explanation part just now. 17 and 18, they go together, okay, most of the time. We have to see, is it under 17? Is it under 18? Okay, so they are quite closely related. Okay, we stop here. The second, the next part of my recorded lecture will cover the second condition. So, exception. I stop.